It's maybe interesting to see whether or not the data protection authorities are going to get ahead of the private sector here. I suspect that those here who are in the private sector are being pounded with questions from technology offices telling lawyers to either get out the way or to give them very clear guardrails as to what they can do. We're sensing that the sophisticated in-house teams are kind of breaking down the workflow that you've heard described. So looking at the inputs, looking at the models, looking at the outputs, analysing the risks and opportunities across each of those. You've heard data privacy is a big feature of that. Clearly IP, clearly other regulatory issues. I've heard antitrust lawyers get excited before today, but certainly today as well, and likewise the obvious ethical and reputational risks. The one topic which was touched on briefly in one of the sessions earlier, and which we as a group thought was kind of quite a scary one for everyone in the room, was the idea that models themselves could ultimately be injuncted on the idea that they were created using data that should not have been used in their creation. And that is something which I think all of us sort of slightly struggle to understand exactly where the technology risk arises, because the models will have been trained on certain data, but the models don't necessarily still use that data when they're in operation, because they are necessarily divorced from it, albeit businesses in this room will probably be fine-tuning, will be calibrating some of these models to the extent that engineering piece is exposed in the way in which the model is made available. And instinctively you'd say, well, the model isn't itself processing the data, maybe I'm okay. But actually, if you look at what's happened, particularly in the States, the FTC has settled a number of cases on the basis that a model which was developed using data that should not have been used for that purpose is effectively blocked. You see that in 2022, for example, in a case against Weight Watchers, where data relating to young persons was used in breach of COPPA and without appropriate parental consent, and the order that flows from that is that the model can't be used. Some of that commentary bubbled up in the UK earlier this year, and the ICO sort of confirmed, at least to the journalists who were asking at the time, that jurisdiction remained within the ICO's remit. You see similar commentary from the CNIL in relation to their guidelines. So I think that is maybe the sort of nuclear weapon that sits within data privacy law and beyond, as to all of these models that people are building on, because you can bet that those who are providing those kind of core foundation models aren't going to be able to offer you that sort of indemnity protection against the use of those models and whether they turn out to be at risk.
So do you think that we already have good tools for these risks, or the assessment of these risks?
Well, it's an interesting question. We touched on some of that in commentary from the Commission earlier, where clearly the way in which people are thinking about AI, driven in part by the EU AI Act, is to think about that risk balancing and to factor in kind of all of the usual things that people in this room know well from their DPAs. Clearly, the ICO has offered some helpful guidance on that, particularly to think about the way in which you are assessing your data sets, thinking about the risk of bias, whether or not you're able to validate those data sets through kind of part of your review process before you launch. But I think increasingly businesses are going to really struggle with the idea that they can test the full data set that they want to use, because they will likely build models in an orchestrated fashion. So that's to say that they will put model next to another model, next to another model, and all of those together will make up a system, but it'll be extremely hard for people to track that risk across their system. And they probably will want to hedge their bets across different providers, so that if one model finds itself in trouble, they have a way of pivoting across those different commercial solutions. I dare say that may be easier in private practice than it is for data protection authorities.